Welcome back to the class video for Module 12, in which we're looking at Melancton Smith's Letters from a Federal Farmer. In the first part of class, we looked at the historical context of the ratification process to set up the contrast between Smith as the anti-federalist and Module 13's Publius, who will present the advocacy or the pro-federalist position. And then we turned to the text and looked at the first, third or little more than a third of the pages, but if you will, the kind of introductory section which sets out primary themes. The main idea to take away from this first part of Smith is his perception that the new federal constitution is a counter-revolutionary or anti-revolutionary document, that it undermines the achievements of the revolution. It does so by exceeding its authority and ignoring the Articles of Confederation, but most critically in the kind of lie that it tells about the division of power between federal and state governments, that it on the face appears to leave responsibilities to the states, but in fact in the operation of government, inevitably it will accumulate and agglomerate power unto itself. Most fundamentally, we saw that for Smith, the primary achievement of the revolution was popular sovereignty, the rule of the people, and that can only happen truly or purely or without corruption in small districts or in locales, reenacting Paine's model of a simple democracy in which we're all sitting under the tree together and everybody gets to raise their hand, yes or no, to every law. The further you move away from that model, you necessarily introduce the possibility for corruption, because the representative is necessarily more distant from the people that they're supposed to represent. So in each of these ways, Smith thinks, the federal constitution is a kind of treason against the principles of the revolution. Okay, in the second part of class now, we can turn to essentially the second half of the reading, and what we're going to see is a kind of laundry list, a checklist of specific provisions of the Constitution to which Smith objects, and his rationale for why they will lead to the demise of freedom in the new republic. So let's turn now and pick up just the page after we left off in part 1 of the class. All right, we left off last time with page 6 and Smith's critique of the House of Representatives and his observation that though the Senate is at least based on states' rights principles, that won't save the Constitution. If we pick up then on page 7, we can see him introduce a new topic at the bottom of the left-hand column. In the second place, it is necessary, therefore, to examine the extent and the probable operations of some of those extensive powers proposed to be invested in this government. He gives us a kind of laundry list here at the top of the right-hand column, but also the category into which he thinks all of these examples fall, in the highlighted passage at the top of the right-hand column. But powers to lay and collect internal taxes, to form the militia, to make bankrupt laws, and to decide on appeals, questions arising on the internal laws of the respective states, are of a very serious nature, and carry with them almost all other powers. These, taken in connection with the others and powers to raise armies and build navies proposed to be lodged in this government, appear to me to comprehend all the essential powers in this communities, and those which will be left to the states will be of no great importance. So for Smith, the great kind of violation of the federal Constitution is the way it empowers the federal government to intervene in the internal laws of the respective states. And if you recall Dickinson, how important that distinction was for the colonists between external and internal, that is, they conceded to Parliament the authority to regulate their external relationships, but they found it to be tyranny, a constitutional violation, when Parliament attempted to legislate within each colony. Smith here thinks that he is defending that principle. So we have a kind of laundry list of powers, but what they all have in common is that they invade the internal laws of the respective states. Certainly for Smith, the greatest and most important of these is the power of taxation, and he picks that up in the next paragraph. A power to lay and collect taxes at discretion is in itself of very great importance. By means of taxes, the government may command the whole or any part of a subject's property. Taxes may be of various kinds, but there is a strong distinction between external and internal taxes. External taxes, he thinks, essentially regulate commerce, again recalling Dickinson, but in the next highlighted passage, but internal taxes, as poll and land taxes, excises, duties, and all written instruments, etc., may fix themselves on every person and species of property in the community. They may be carried to any lengths, and in proportion as they are extended, numerous officers must be employed to assess them and to enforce the collection of them. So there is a kind of natural curb or parameter to external taxes to the extent that they are primarily applied to trade and commerce. But there are no limits to internal taxes. Why? Because they affix themselves on every person and species of property in the community. What Smith is describing here is this power of direct taxation. That is to say, under the Articles of Confederation, the Continental Congress was only able to assign each state its quota of the national debt or the national budget, and then left it up to each state to actually take property away from individuals. Whether or not the federal Constitution would empower the federal government in the same way is a matter of debate during the ratification process. And Smith takes up that question. It's a little bit jumbled up in the organization of the letters, but if we skip ahead to letter 4 here on the right-hand column of 10, we can see him address just this question. He says at the bottom of the right-hand column in the highlighted passage, by Article 1, Section 2, representatives and direct taxes shall be apportioned among the several states. And in the same article, Section 8, the Congress shall have power to lay and collect taxes, duties, and such for the common defense and welfare, but all duties, imposts, and excises shall be uniform throughout the United States. By this first recited clause, direct taxes shall be apportioned on the states. This seems to favor the idea suggested by some sensible men and writers that Congress, as to direct taxes, will only have power to make requisitions. But the latter clause, power to lay and collect taxes and such, seems clearly to favor the contrary opinion. And in my mind, the true one, the Congress shall have power to tax immediately individuals without the intervention of state legislators. So Smith sees that although that first clause that he cites here in Article 1, Section 2, which we saw the debate around that in Madison's notes on the convention, that representatives and direct taxes shall be apportioned, recalls to their mind, to Smith's mind, the language of the Articles of Confederation. But Smith sees that in conjunction with the powers granted, the tax power granted to Congress in Article 1, Section 8, that the latter clause negates the former. Again, this theme in Smith that he sees through the pretenses of the federal Constitution and the defenders of it, and he understands how the Constitution will actually operate. Now, if we return to the discussion of taxes above, after mentioning how many tax collection officers and laws that will have to be imposed to empower the federal government in this way, Smith comes to his second point on the right-hand column of 8. If we look at the highlighted passage at the top, by this plan there can be no doubt, but that the powers of Congress will be complete as to all kinds of taxes, whatever. Further, as to internal taxes, the state governments will have concurrent powers with the general government, and both may tax the same objects in the same year. And the objection that the general government may suspend a state tax as a necessary measure for promoting the collection of a federal tax is not without foundation. What is the foundation for that charge? Article 6, which declares that any law or treaty of the federal government is supreme over the law of any state government. So if a federal tax law and a state tax law came into conflict, Smith is here teasing out, the federal tax law has to be paramount. Well, the effect of this is that the federal government can tax as much as it wants or as much as it can and leave no property left to be taxed by the states because the federal law is paramount. If you take all of these tax clauses together and come back to the left-hand column of 8, in the second highlighted, or this first full paragraph that starts about a third of the way down, there's this wonderful kind of declamation by Smith. He can't believe what he's seeing. He writes, "When I recollect how lately Congress, conventions, legislatures, and people contended in the cause of liberty and carefully weighed the importance of taxation, I can scarcely believe we are in serious in proposing to vest the powers of laying and collecting internal taxes in a government so imperfectly organized for the purpose." So here you can see Smith and all the anti-federalists who agreed with them utterly dumbfounded that they just fought a revolution against the power of a central government, parliament, to impose internal taxes on them. And not 8 years after the end of the war, here comes this group of yahoos that are proposing to create a powerful central government with these extraordinary powers of taxation. This is a wonderful passage that points out the counter-revolutionary or anti-revolutionary character of the federal Constitution, at least as it was perceived by its critics. Anti-federalists like Melancton Smith thought that they were standing up for the true principles of the revolution against these heretics like James Madison, who were threatening to impose on them the exact same system that they had just fought against. A second issue that was foundational for Smith and the other anti-federalists was the Constitution's provisions for raising an army. We did not review those particular portions of the convention debates in Madison's notes, but one of the foundational principles or kind of consensus values of the revolution lay in the value of the state militias or the colonial militias and the evil of the British Navy and Army. It would have been a virtually universally accepted principle among the framers that the moment a country has a permanent professional standing army, that liberty is at an end, because the only useful purpose for a permanent army is for the government to use it to oppress its citizens. If the government was truly defending the nation, the citizens would surely turn out and volunteer through their militias to defend the nation. There's no need for an army. If we look at the right-hand column of 8 and come down just about halfway down the highlighted passage, Smith notes that by the Constitution it is proposed that Congress shall have power to raise and support armies, but no appropriation of money to that use shall be for a longer term than 2 years. So this is the primary constitutional restraint on a professional army. The monies that are used to pay for that army cannot last for more than 2 years. Well, we know living in the 21st century that is not a practical barrier to maintaining a permanent professional army. At the bottom of the right-hand column of 8 and then extending into 9, Smith writes, "When an army shall be once raised for a number of years, it is not probable that it will find much difficulty in getting Congress to pass laws for applying money to its support. I see so many men in America fond of a standing army, and especially among those who probably will have a large share in administering the federal system. It is very evident to me that we shall have a large standing army as soon as the monies to support them can be possibly found." Now, this is a kind of backhanded dig at George Washington. There was certainly no one in the new United States who was a bigger advocate for empowering the central government so that it could properly equip and train a defense force than George Washington. And of course, his stature is enormous and carries enormous influence with public opinion. But Smith is nevertheless correct that the supposed prohibition or barrier or curb on a professional permanent army in the Constitution, that the budgeting could only last for 2 years, is no practical barrier. We see that today. Congress certainly has the power to withdraw funding for the military at any time that it chooses to do so. But it is politically impossible for them to do so. It is a kind of third rail of American politics. There would be no party could maintain its presence in the Congress if it refused to extend military funding more than 2 years at a time. Once again, for those who were critics of the new Constitution, they perceive in this scheme to create a professional permanent army a replication of the great evils of the British Empire that they had just fought a revolution to escape. Smith raises a third issue on the right-hand column of 9 when he turns to the judiciary. He says at the beginning of the paragraph at the top of the right-hand column, there are some powers proposed to be lodged in the general government in the judicial department, and I think very unnecessarily. And then he describes what he calls concurrent jurisdiction, which is an analog to his concurrent power over taxation in the highlighted passage. Actions in all these cases, and he's just got done listing those jurisdictions that the Constitution allows. He says, actions in all these cases, except against a state government, are now brought and finally determined in the law courts of the states respectively, and as there are no words to exclude these courts of their jurisdiction in these cases, they will have concurrent jurisdiction with the inferior federal courts in them, and therefore, if the new Constitution be adopted without any amendment in this respect, all those numerous actions now brought in the state courts between our citizens and foreigners, between citizens of different states, by state governments against foreigners, and by state governments against citizens of other states, may also be brought in federal courts, and an appeal will lay in them from the state courts or federal inferior courts to the Supreme Judicial Court of the Union. The appellate nature, that is, that cases filed in state courts would inevitably have the right of appeal because of the supremacy clause in Article 6, which declares all federal rules superior or supreme over state rules, you'll necessarily end up with a kind of pyramid structure, which is exactly what we have today. This should be a familiar idea to you, that cases start at lower courts, in state courts or even county courts, and get appealed if they have national implications all the way to the Supreme Court. But this is radically new from what Smith is familiar with. If we look in the left-hand column of page 10 in the first highlighted passage, the judicial powers of the federal courts extend in law and equity to certain cases, and therefore the powers to determine on the law in equity and as to the fact all will concentrate in the Supreme Court. These powers, which by this Constitution are blended in the same hands, the same judges are in Great Britain deposited in different hands, to wit, the decision of the law in the law judges, the decision in equity in the chancellor, and the trial of the fact in the jury. It is a very dangerous thing to vest in the same judge power to decide on the law and also general powers in equity. And then he summarizes at the end of that paragraph, I confess in the Constitution of the Supreme Court as left by the Constitution, I do not see a spark of freedom or a shadow of our own or the British common law. Now this takes us pretty deep into the weeds of English legal history, and we don't need to go all the way down that road. But the idea that there is a single pyramid structure and a rational organization for all laws passed in the nation is a topic that we referred to when we were talking about Article 3 in Module 11. The Madisonian turn will include a profound change in the way that we understand what is law. Today, we're very comfortable with the notion that the laws are whatever the legislature has passed, which infers and nothing else. That is to say, if a legislature has not positively acted on a subject, then citizens are free to act as they please in the absence of legislation. That's a radically new idea. That's a very modern conception of law. And it's one of the great consequences of the Madisonian term. Prior to the adoption of the federal constitution and this change, it would have been much more common to think about law having multiple sources. There are different kinds of courts which hear cases regarding and enforce different kinds of law. For our purposes, it's enough to consider the state of our national constitutional law if there was no federal court system. If each state's Supreme Court was the final word on what laws were and were not effect within each state, you can imagine the kind of patchwork quilt of different legal principles we would have across the country. Each state would have very different rules and what was constitutional and what was not. That is unnerving to us as modern Americans accustomed to this civic culture. We are very accustomed to the idea, and we expect the idea that there's kind of a rational pyramidal structure to the logic of laws. That is, we would consider it anomalous if a local law, if a county was allowed to have a rule that violated in principle any level of law above it. That is, city law, state law, or federal law. We might ask, how could you possibly have a situation in which people were allowed to do one thing at a locality while the national law said that they were not allowed to? That would show the lack of sovereignty of the national government. Well, that's exactly the state of law in a kind of pre-modern world or in a pre-Madisonian world. It is simply true that two different courts that get to enforce two different kinds of laws would reach different decisions given the facts and the principles that they were there to enforce. And that's what Smith is reacting to in his mind, in the same way that you would start out with concurrent taxation power, but inevitably, because the federal power is supreme over the states, whenever they came into conflict, the state would have to give way to the federal. He sees a similar sinister design in this blending of state and federal law to have one system. The radicalism of this change, which again we accept as normal in our modern American legal system, but the radicalism of this change in 1788 is really important, because when we look at the Bill of Rights when it was adopted, we see how much the individual rights in the Bill of Rights are focused on protections against courts. It was this theme in Smith was one of the most powerful arguments against the Constitution. This fear not simply that you would have a national court system enforcing the national laws, but that eventually all of the diversity among the states would have to become homogenized. Now for Smith, the supreme, final, conclusive evidence that this won't simply be a natural unfolding, but is indeed a kind of plot that has been hatched by the advocates of the federal Constitution, is in the necessary and proper clause. He picks it up on page 11. Now, if you recall, Article 1, Section 8 lists the powers of Congress. Congress shall have the power to lay and collect taxes, establish post office and roads, determine weights and measures, and all the rest. And when you come to the bottom of that list, it's a list of 17 things. And then the 18th clause says, and then to make all laws which shall be necessary and proper for carrying into execution the things listed above. This clause, seemingly hidden down here at the bottom of this list, the 18th thing, but actually worded in a radically different way than any of the preceding 17 things, proves to Smith that this is actually a plot hatched by the designers of the Constitution. If we look at the right-hand column of page 11 in the highlighted passage, Smith writes, "It is proper the national laws should be supreme and superior to state or district laws. But then the national laws ought to yield to unalienable or fundamental rights. And national laws made by a few men should extend only to a few national objects. This will not be the case with the laws of Congress. To have any proper idea of their extent, we must carefully examine the legislative, executive, and judicial powers proposed to be lodged in the general government and consider them in connection with a general clause in Article 1, Section 8 in these words: to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States, etc. Continuing, it is almost impossible to have a just conception of their powers or of the extent and number of laws which shall be deemed necessary and proper to carry them into effect, till we shall come to the exercise those powers and make those laws. This clause, Smith rightly sees, explodes all pretenses to the federal government being a government merely of enumerated powers. Any pretense that the national government is limited in its sovereignty because it's only permitted to do those things which the Constitution specifically permits it to do. The necessary and proper clause from Smith's perspective brings together all these diverse examples of the ways in which you set state authority against federal authority, and inexorably federal authority will erode state authority and take it over and become dominant to it. We don't even have to imagine a kind of little physics machine and watch this thing play out. It's the very purpose of the document, because we find this clause hidden, buried in this list of 18 things supposedly empowering Congress to do. It is the design of the machine, it is the intention of the designers that this federal supremacy should absorb all the states. Now, we'll see when we get to Publius in the final module, that's a pretty close estimation of Publius's description. Publius will write at one point that the states should be like mere counties to the national government. Now, there's one final issue that Smith wants to raise in this piece. On page 12, he is particularly concerned about the absence of a Bill of Rights. He notes at the bottom of the left-hand column of 12 that there is a kind of partial Bill of Rights in Article 1, Sections 9 and 10. If you recall, Article 1.9 is a set of prohibitions on Congress, things that Congress are not allowed to do, and Article 1.10 is a set of prohibitions against the states, a list of things that states are prohibited from doing. Smith writes in the highlighted passage at the bottom of the left-hand column of 12, in fact, the 9th and 10th sections in Article 1 in the proposed Constitution are no more nor less than a partial Bill of Rights. They establish certain principles as part of the compact upon which the federal legislators and officers can never infringe. Next highlighted passage, on the whole, the position appears to me undeniable that this Bill of Rights ought to be carried farther, and some other principles established as part of this fundamental compact between the people of the United States and their federal rulers. And we imagine that Smith would adopt kind of a highlight list, or a top 10 list, if you will, of those rights that were recognized by the different states in their bills of rights. But notice the ones that he specifically lists. First he mentions religion, but then in the highlighted passage in the next paragraph, as freedom from hasty and unreasonable search warrants, warrants not founded on oath and not issued with due caution for searching and seizing men's papers, property, and persons, and trials by jury in civil cases. And he goes on at some length about the ancient British right, or the ancient common law right of trial by jury. Again, it is his particular focus upon this new judicial branch, this new federal judiciary, and this new conception of a pyramid structure of American law that most concerns Smith. And so when he comes to list rights that he would have in an expanded Bill of Rights, he's primarily thinking about guardrails or limits on the new federal judiciary. This commentary on the absence of a Bill of Rights, although it's a kind of concluding point in this excerpt that I've given you in Smith, was in fact one of the principal rallying cries of all the different viewpoints represented by the Anti-Federalists. Virtually every Anti-Federalist came to this critique of the federal Constitution, and indeed it was one of the biggest complaints even among those people who supported the Constitution. It's primarily the concession or the negotiation within the two key ratification conventions in Virginia and New York, a kind of gentleman's bargain among the critical kind of moderate delegates that were trying to work out a compromise, that the first Congress, when it met, would draft a Bill of Rights. That compromise or that agreement was fundamental to getting those last key votes in both Virginia and New York and allowing the Constitution to be ratified. So it forms a kind of minor theme here in Smith, but it's important to include it because it really was much more important in the historical debate as it unfolded. The most important theme to take away from the Anti-Federalist perspective is how much the people who were opposed to the Constitution felt like they were defending the principles of the Constitution. That was their perception, their perspective, and that the advocates of the federal Constitution, above all James Madison, were trying to undo the achievements of the Revolution. As we'll see in the final module when we read Publius, Madison conceives of himself as not going backwards from pre-revolutionary times, but moving forward to a post-Aristotelian model, a new system of government that the world has never seen before. And that's really the fundamental divide between the Anti-Federalists and the Federalists. The Anti-Federalists are still thinking in terms of 1776. They're still thinking in terms of the logic of the state constitutions that were written during the Revolutionary period. The final passage of Smith really highlights his perspective, a kind of pre-Madisonian perspective, if you will. If we look at the bottom of the left-hand column of 13, this is Smith's kind of summary conclusion to all of his arguments. He writes, "While power is in the hands of the people, or the democratic part of the community, more especially as at present, it is easy, according to the general course of human affairs, for the few influential men in the community to obtain conventions, alterations in government, and to persuade the common people that they may change for the better, and to get from them a part of the power. But when power is once transferred from the many to the few, all changes become extremely difficult. The government is in this case being beneficial to the few, they will be exceedingly artful and adroit in preventing any measure which may lead to a change, and nothing will produce it but great exertions and severe struggles on the part of the common people. Every man of reflection must see that the change now proposed is a transfer of power from the many to the few. And the probability is the artful and ever-active aristocracy will prevent all peaceful measures for changes unless when they shall discover some favorable moment to increase their own influence." Fundamentally, Smith sees the political world, his kind of chemistry set for understanding how Constitution works is rooted in Aristotle. It's a struggle between the many and the few, the poor and the rich. And the rich are ever plotting to steal power from the many, which is where it properly belongs in a democracy ruled by the people. And notice his sense that the change really only goes in one direction. It goes from the many to the few, and it's extraordinarily difficult to turn it in the opposite way. Think of that Polybian cycle of the Aristotelian forms, from the one to the few to the many, and the kind of inexorable forces of the history of the kind of laws of history that propel human society through this endless cycle. That is a profoundly Aristotelian way of understanding constitutional order and political society. From Smith's perspective, another anti-federalist perspective, the revolution was the triumph of the many over the few. What the new federal constitution proposes is to invert that achievement, to put the few in power over the many. When we turn now to look at Publius in the final module of the course, we want to appreciate that that's the rhetorical challenge that James Madison and Alexander Hamilton face, that they know that the people who are opposed to the Constitution consider them counter-revolutionaries, consider them as part of a scheme to reinstitute aristocracy and monarchy in America. And so the rhetorical challenge for Publius is to convince his audience that this change represented by the federal Constitution is not a return backwards to something that preceded, but is an evolution forward to a thing that's never been tried before. Yes, it's got these three branches, and yes, we're separating powers and checking and balancing, but we're not separating powers among the many and the few. We're checking and balancing among these other things called legislative, executive, judicial. That rhetorical case is essential to the success of the Madisonian turn. And the rhetorical argument, the persuasive argument to convince delegates in the conventions to approve the new Constitution is the central focus of the final module of the course.